Conspiracy is the federal government's baby. Okay, conspiracy tracks exactly with how the government makes cases in the first place, which is starting with smaller individuals and working through the chain to try to get to their main target and their main individuals. And the law of conspiracy itself, in the government's eyes, and often in the cases that we deal with, it does create a wider net of individuals who can get caught into a criminal charge. And the specific nuances of the conspiracy statute, certain nuances of the statute, do make it, in some cases, easier for someone with less conduct or less exposure or less alleged bad acts to get drawn into a much larger conspiracy or much larger charge. For example, in a conspiracy, while it does require a knowing plan, an unlawful partnership in crime, and that the individual willfully joined that partnership, there are other aspects of conspiracy that the government loves, which is that not every member of the conspiracy need know what everybody else is doing in the conspiracy. Not every member of the conspiracy need to know even the other individuals who are members of this alleged conspiracy. And even an individual under the statute who plays a small role can be held responsible for the entire conspiracy itself if charged as a co-conspirator. So the government uses that in order to prey on the smaller individuals in order to try to get cooperation and try to build a bigger case against their true targets. So it is their favorite tool without a doubt, because seemingly innocent people can find themselves wrapped up in a conspiracy charge, even if they had the smallest involvement. So to be part of a federal conspiracy, at the heart of a conspiracy charge is a unlawful agreement or a partnership, to a criminal partnership to achieve an unlawful purpose. What the purpose of the conspiracy is does have to be proven, but not every member of the conspiracy needs to know what everybody else is doing or what their own individual plan is. It really is the partnership, the agreement to join with one or more other people. Two or more people have to be involved. So, an agreement to join with one or more other persons in order to achieve an unlawful purpose. There does have to be at least one overt act. An overt act is something that is done, whatever it might be, in order to achieve the goal of the conspiracy, but only one person in the conspiracy has to do one overt act. Not every person charged in the conspiracy each has to do an act. It is the agreement itself, the partnership in crime, so to speak, that is at the heart of the conspiracy statute. They can. So when it comes to the conspiracy charge, even if an individual played a small role, they have exposure. If they agreed with one other person, there could be 500 people in a conspiracy, but if they agreed with one of them to achieve a common plan, then the government can, if the other elements are met or they believe the other elements are met, can charge that individual. Now, it's not just the agreement that needs to be proven, and this is commonly forgotten, or is a common misconception, you could say, by people who are charged with conspiracy, is they have to enter this agreement knowingly and willfully. So with a knowing purpose to achieve to violate the law, to achieve a common unlawful plan, and willfully being not by accident, not by mistake, with the actual intent and plan to carry out this conspiracy, regardless of whether or not they never touched any money. They don't actually have to do anything other than agree. But it's not as simple as that. The DOJ, the government, tries to make people feel that it is, but this knowingly and willfully, which means it cannot be by mistake, it cannot be by accident, it has to have a knowing and conscious and voluntary and willful agreement to enter into a criminal partnership. But yes, people who do not do anything, do not take one overt act in order to achieve the common plan, can still be charged as a conspirator. I think when people think of conspiracy, commonly they think of organized crime, or they think of a cartel or some large scheme involving multiple people to achieve an unlawful goal. Conspiracy, especially the way that it's, I would say, abused in the charging by the Department of Justice, and how often they're trying to do that to wrap up people who don't deserve to face the federal justice system but are still getting wrapped up into conspiracy charges. They think it has to be some big grand scheme, but really it doesn't, unfortunately, according to the statute. Another misconception is alternatively and almost conversely that just because I was charged with conspiracy, I must be guilty. They got me. I don't have to have done anything. This was involving other bad people and they did bad things. We cannot forget, and people often forget or are not properly advised by counsel, that they still have to prove that you knowingly and willfully joined this plan. It's not enough to just enter into a joint venture with someone that turned out to be criminal. You had to know at the time you agreed to achieve something unlawful with another person, you had to have known that that was the plan, that it was criminal. So it can't just turn out to be criminal later. And that's a common misconception, that a joint venture that is seemingly legitimate and you believe is legitimate can then become a crime. The partnership itself has to be criminal. It is a partnership in crime. And that is commonly a misconception. And people think they don't have options when it comes to conspiracy charges because, yes, they can have a small role, they can get wrapped in, but they do if they have the right defense. So, cooperating witnesses are everything to conspiracy cases. When the government's bringing a conspiracy case, they are specifically targeting individuals, even if it's before the criminal charges, in the form of subpoenas, target letters, knocking on doors, coming to places of work, phone calls, to try to identify the individuals that they believe are the most vulnerable and have the most to lose and are the most likely to want to turn and cooperate then against the other individuals in the conspiracy, because there is nothing better in the government's mind than a cooperating witness who will say, yes, I am a conspirator. I entered into a criminal partnership with this other individual, and then that individual cooperates, and it goes and goes and goes until the government has a full picture of the conspiracy. Conspiracy is not the easiest thing to prove when nobody within the conspiracy cooperates. Very rarely, if ever, will you have a conspiracy prosecution that does not involve at least one cooperator. Now, whether that person was charged or not is another thing, but someone who has fear and criminal exposure and who the government has bullied into providing information, that's really how they build a conspiracy case. So cooperators are everything, and you have to know how to deal with them. There are absolutely ways to deal with cooperators and to minimize the harm that a cooperator can do to your client. There are various defense strategies when it comes to conspiracy cases. Attacking the knowing and willful elements of the conspiracy are always going to be at the forefront. Did the accused, did your client knowingly and willfully join a conspiracy? Did they engage in a criminal partnership as opposed to them believing that they joined into a legitimate business that turned out to be criminal? The agreement itself, the partnership itself, and whether there is evidence of that is at the forefront. Now, the government does not have to show and the statute says this, and the instructions on the law that a jury reads says this. They don't have to see a shaking of hands. They don't have to see a text message that says, hey, let's get together and violate the law. We don't see that very often. They're allowed to prove the knowledge element of conspiracy when it comes to did this person have the actual intent to knowingly and willfully join through circumstantial evidence or through context. So that is usually the element that we are focused on very often. The other way I would say that's probably most common among different ways is attacking the cooperating witnesses, attacking the credibility of the cooperating witnesses. So, in a conspiracy case, because you so often have cooperators, there are ways to impeach them, there are ways to attack their credibility. There are laws and instructions that say to a jury, if a matter goes to trial, a conspiracy case, they are allowed to consider, and they actually, must consider that someone who took a plea deal in order to testify, you can look at them, ladies and gentlemen of the jury, with less credibility automatically. Someone who is cooperating, someone who received immunity, they automatically lose credibility and are actually instructed to do so and for this to happen by the judge. So attacking the credibility of the cooperators and attacking the knowing and willful partnership itself, I would say, are the two main defenses we have in a conspiracy case. The risk of communicating with co-defendants during an investigation is very risky, but it can also be very rewarding if done properly. So, the rewarding side, let's start with that. When people are charged in a conspiracy, one of the best defenses you can have is to stay together, is to stay as a unit, okay? And that's not very common. Usually someone is going to decide that they want to, for self-preservation or whatever their own purpose is, to cooperate with the government. But if you can stay together, there's something known as a joint defense agreement whereby everybody promises to each other that we are going to stick together to achieve a common goal. It's just like a pack of wild animals or buffalo drinking at the watering hole. They stay together. It is strength in numbers. It's the same thing in a conspiracy charge. So if your counsel knows how to navigate those kind of agreements and those strategies, it can be very favorable. It can also be extremely risky to speak to your co-defendants because you never know, if you don't have some sort of joint defense agreement, who is talking to the government and who isn't. So you have to be extremely careful when it comes to that, and you have to run everything by your attorneys because it can really backfire. In general, okay, you have to have your attorney evaluate the evidence. Okay, that's first and foremost. Does the government have the evidence in order to prove the elements of conspiracy? The client might not believe that they truly had criminal intent and that they were part of a criminal conspiracy and that they entered into this partnership. But given that after trial in federal court, there can be such severe penalties, and there may be ways to negotiate through cooperation or through other means in order to achieve your best shot at staying home with your family if you have a family, or avoiding incarceration in general by negotiating and by cooperating. That's really going to be on a case by case basis. So there are a lot of incentives, especially in conspiracy cases, to cooperate and to try to work out a plea for certain individuals in the conspiracy, because there are multiple individuals who you have an opportunity to provide information about. That's the nature of a conspiracy versus being charged alone. So, yeah, it's very common for individuals to want to cooperate. And sometimes that is often the right strategy, but every case is different and it just has to be evaluated with competent counsel.